Oh, yeah, he didn't show?
Did not show. Yeah, he didn't show.
All right, Daniel, could you take this, Justice Santoya? Are you ready? Yes. Court is calling 2022 CR 10024, State of Texas versus Jesse Joe Santoya. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
For the defense?
Jonathan Ross for the defense, Your Honor.
All right, this hearing was scheduled at 9 a.m. It is now 2 p.m. The defendant did not appear in court at all today. Have you had a chance to get in touch with your client, or have you been in touch with your client?
I have, his family called to say that he doesn't have a phone, Your Honor. His family did call this morning to say that he was on the way, he was having transportation issues. But I haven't been able to get in touch with him since, and I haven't seen him since, so that is the situation at the moment.
All right, Deputy Laura, has there been a Jesse Santoya?
No, Your Honor.
All right. State?
Your Honor, state would move for a lawful procuring for a warrant to be issued for his arrest.
All right, that'll be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you very much, Your
All
Honor.
right, thank you.
Rob, just in time.
All right, and now we are on Julian Reyes. If you'll come down, please. Okay, I'm gonna look at it. So you're saying that you should be the Cowboys kicker?
I'm assuming that
By the way, after this, I
I'll have a chance to.
But here's the thing. Did you make that extra point under pressure or not under pressure? Oh, you could make it under pressure? Okay.
Yeah. We can only give you the shot. With the girlfriend.
All right, I'm gonna write a letter. Hopefully they will listen to me.
Write it to Jerry.
And you know, when I write that letter, it's gonna be one of those cases.
Send him a
Yeah.
video, send him a video.
Okay, I'm gonna send a video. And you know, it's gonna be one of those things where you could win
Yeah.
$250,000 if you make it. That's gonna be the kind of pressure.
Not an open trial. Not as my witness.
Sure. Okay, that I
I
appreciate
mean,
it.
what's the worst that could happen?
They do have open tryouts.
Get out of here, fat old man. Okay, I can live with that.
Teams do have
They
open tryouts.
probably do, but
All right, I'm gonna get you an open tryout.
There, I think we're with the indictment is to just.
No, just as is, pleading one, dismissing the other, PSI, straightforward. Yeah.
All right, the court is going to call 2022 CR 3983, State of Texas versus Julian Reyes. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
James Turkey, Mr. Reyes.
Are you Mr. Reyes? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery and did you review it with your client?
Yes, yes, ma'am.
This court will find that the state is in compliance with discovery. Mr. Reyes, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, I do.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
Stated, it appears that you're proceeding on the indictment as presented. Is that correct?
Yes, Your Honor.
Mr. Reyes, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I do.
Did you understand you're charged with aggravated robbery? That is a first degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to life in prison and up to $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Reyes, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 15 years in the prison. There's a $1,500 fine. State opposes your application. They will take in consideration 2022 CR 11025. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I did.
Counsel, have there been any such motions?
No, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea?
State offers State Exhibit 1 and all attachments.
Without objections, Judge.
Mr. Reyes, I'm showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding the guilt as you've applied for deferred adjudication. Your sentencing will take place on February 9th. I will make a decision on your application based upon the PSI report and any other evidence that's presented to me. Does he need a top evaluation?
I definitely would recommend one. Yes, ma'am.
All right, so we'll do a PSI and a TAP evaluation. Is there anything else?
No, ma'am.
All right, thank you.
Thank you, Judge.
Thank you,
You're
Judge.
welcome. All right. Bye. And you know what? I'm serious. I'm gonna, I guess if you do get the job at the Cowboys and they give you a position, then I'm sort of like your agent
Well,
and I get a percentage.
completely unrelated to our relationship in the courthouse.
That is so true.
I will get you tickets.
No,
Cowboys play sticker.
Yeah.
No, you don't want tickets?
no, I can watch it from television.
Okay. Get you a tour of Jerry.
Yeah.
I think you will be more of a Cowboys cheerleader, Jim, to be fair.
When I was in the DA's office, we used to do this all the time.
Mhm.
We'd all run out to some field and throw down, a little bit of lunch money and see if I could bang them from 40, 50 yards.
Do you know what?
All the time.
I remember them showing me a video of Christian Hendrickson running
Oh, yeah, full suit.
full suit with dress shoes.
About 6-minute mile.
Yes,
Yeah.
and Charles Buck
Uh-huh.
had to pay him for that.
Well, he ran, let me just say one last thing and I'll leave.
No, no.
Never mind. Little Lance Aldridge. You know
Yes,
Little Lance
Yes.
Aldridge. 2 weeks ago, we went hiking over the weekend and I said, oh yeah, I was just at that place. He went out there and ran a 100 gallon. You know what that is?
Yeah.
That is 6200 in one day.
no,
62 miles.
I cannot run 62 miles in one day.
3.5 hours. He did.
That is
That-
insane.
That blows my mind too.
Well, here's the
So
thing.
Little Lance Aldridge, endurance
Well-
runner from,
Now, you know what that tells me about little Lance Aldridge? That tells me that we need to have him examined.
we did put some rocks in his pocket because he couldn't weigh but 8 pounds. Lost weight. He was already little. Yeah.
But you're telling me 62
One
miles.
day. Took him
In
8.5
one day.
hours. The ones that won the race, the like real pro level, did it a little over 6 hours.
Oh my gosh.
That's what I said.
So that's why I'm saying that we need to have him examined by a doctor.
He's on the
And I mean,
floor.
put him, do the
You're the boss of him. Call him over.
full X-ray. None of this, just somebody's checking your heart.
sent me a video of his finish. I could not, I thought about that and I was blown away too. I was like, wow. There's so few humans on the planet who can run 60
Well,
miles.
here's my question. Did he do what somebody did in the New York Marathon where they saw them at the beginning and then they got in a taxi cab and then
Oh,
they got
recently
out
or back in the day.
in the day
Oh, Rosie Ruiz.
and then they got out?
Rosie Ruiz did.
Yeah, no, yeah, that's it.
And you know how she got caught? She forgot to splash water on her face. And say, oh my gosh, that was such a long run. All right, who's here on Adrian Soto?
God bless this.
It's a bigger order.
Yeah, the paperwork.
Okay, all right. Well, what we'll do is we'll bring in this witness for them to finish with them, and then we'll take up Mr. Soto on break. And is Cornelius next door with his?
Yes.
And they're going over paperwork?
I mean, just make sure she.
Okay, yeah. Let's have her take the stand. And Norma, here is Soto and Castillo, they're coming back tomorrow. She said she'll have the paperwork done. But she's gonna be here exactly at 9.
No, not for you.
And then on Soto, we'll do it during the break because the defense is telling me this witness is gonna take some more time.
Would you let me know that I can test?
Yes.
You want them down here?
Yes, go ahead and line them up because I want us to start exactly at 2:15.
Interpreter.
Ah. Norma, can you?
She's just finished. So.
Oh, no
she's
problem.
heading down.
Okay, and Norma, can you see if the interpreter can come down?
I mean, Your Honor, I can interpret, but I don't think you will. I don't think you would.
It won't work. Hi.
You can bring them out.
Did you finish with his paperwork? Oh, can you bring Cornelius's client out then? And Vashawn, can you see, can you grab Michael and see if he could take this plea?
You got it?
Unless Daniel's gonna make it down here, so.
Daniel, can you come up now? Can you let us see what this is? Okay. He's coming back. He's about to be away.
All right, thank you. Yes.
Okay.
Just one moment. Mr. Cox, James Toshi seems to think that he would be a good punter. I have my doubts. It's easy to punt when you, hi, oh, thank you.
Oh, what's going on?
Oh, can you take this plea?
That's
I
all.
can, sure.
Yeah.
Oh, thank you.
He's the one that.
Daniel's here.
Oh,
Yeah, I remember.
Stick
now we have an abundance of prosecutors from criminal trial division. Oh, no, you're there. Mr. Cox, you're right there.
The jury's ready.
And
Yeah.
Norma, we're just waiting for the interpreter to come down.
Yeah. so you can- there's a thing for you. Are you finished for coffee?
Okay, because I told them, yeah, okay.
Look at this lesson. You need to press down and up.
Anything weird on the indictment or not?
Oh, we do have an interpreter. She is here. All right, the court is calling 2022 CR 4109, State of Texas versus Benito Vasquez. Can I have parties announced for the record for the state? Defense. Are you Mr. Vasquez? Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Vasquez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? I need you to speak up, okay? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, you're proceeding on the indictment as presented.
Yes.
Mr. Vasquez, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places? Understand that you're charged with theft under $2,500 enhanced. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Vasquez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? According to the plea bargain agreement, punishment is to be assessed at 65 days in the Bexar County Jail. There's a $1,200 fine, time and money to run concurrent. There are no applications.
That's correct.
And did you understand that to be the plea? Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No, Your Honor.
Then to the offense is charged. How do you plead? Guilty, not guilty, or no contest? State any evidence?
State offer, state exhibit 1 and all attachments.
No objection.
Mr. Vasquez, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court is finding there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We ask the court to honor the agreement.
All right, the court will follow your agreement, sentence you to 65 days in the Bexar County Jail under 12.44 of the Penal Code. There's a $1,200 fine, time and money run concurrent, and the court will show that the judgment is satisfied. Anything else with regards to sentencing?
No, Your Honor.
Mr. Vasquez, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. We can go off the record. Mr. Vasquez, you got to stop stealing. Otherwise, you're going to find yourself living your life at somebody's jail or at somebody's prison. You understand? All right, good luck to you.
Judge, can I approach it? Should just take 1 minute.
Yes.
This is for the felon's action. We filed a motion, it's been accepted, for the witness who's in custody in the other county to be brought over for that, crew as
Okay,
a dozen cases.
all right. Figure, you're welcome. All right, so are parties ready to proceed on 2022 CR 2308, State of Texas versus Jose Raimundo Perez, State
Yes,
Defense?
Yes, Your Honor.
All right, we have an interpreter present. If you could raise your right hand for me, please. Do you solemnly swear or affirm you will faithfully translate from English into Spanish and from Spanish into English, so help you God?
I do, Your Honor.
And could you state your name for the record?
Vicky Cavazos Jones.
All right. And whenever you need a break, just let us know.
Yes, and if I may, Your Honor, there is a form that I need you to sign.
Yes,
And then when I be replaced, I don't want to interrupt the courts. if I
Sure.
approach.
yes. All right, and State, do you have your witness ready? She can come and take the stand. And David, we'll take up your matter in a break. Oh, I'll fill it out and have the coordinator give it to you, so I can fill out everything. All right. We can bring the jurors in.
All right, for the jury.
We came close to the 2:15 mark for you guys. We're so close. All right, everyone, please be seated. And ladies and gentlemen, sometimes we'll need to take a sharp break so we can switch out interpreters so they can get a break with translation. All right, defense. You may continue with your cross.
Thank you, Your Honor. Marissa, and forgive me, I don't remember exactly where we were, but I think we were gonna get right into the allegations surrounding this case.
Okay.
I think you testified earlier that you were asleep
Yes,
when you're saying that this incident happened, is that correct?
Correct.
Now, do you recall if you were asleep or if you were passed out from alcohol?
no, I was asleep.
And you testified that you were, to the best of your recollection, in a dark room with the door closed.
Originally,
At
when I was
first,
going to sleep,
yes.
yes,
And then when you woke up,
the light was on.
the light was on.
Correct.
And the door was open.
Correct.
And let me back up a little bit. Between the time that you went to the bathroom and the time that this allegedly happened, did you say that your boyfriend had come in to check on you?
Yes.
And what happened when your boyfriend went in to check on
So it was just him making sure that I had gotten back to the room safe and sound. So I had gone to the bathroom, and when I had gone back into the room, I had laid down, and I guess I didn't cover myself and close the door. And so he covered me and he closed the door. And that's when my boyfriend had gone back outside, and I had stayed asleep for several hours after that. So when I was woken up, it was around 5 a.m. It was,
Well, let me take it little by little, if you don't mind. So when you went in to check on you,
Mhm.
did you wake up?
No.
Did somebody tell you that they went in to check on you, or do you recall that?
he had told me later that night that he had gone in to check on me and make sure I got back to the room.
So what you just told the jury were not your words, right?
Correct.
Those are your boyfriend words?
Correct.
Okay, so to be clear, that's not something you remember.
No, I was still asleep at that time. Like I had gone straight back to sleep after laying back in the room.
Do you know if your boyfriend kissed you or touched you or did anything other than cover you? When he came in to check on you?
No, I wouldn't know.
You wouldn't know.
I was asleep.
And in fact, when you say that you later woke up to the feeling of somebody touching you, at first you thought it was your boyfriend, right?
I assumed because it was a room, like I wouldn't expect to turn around and see some random person standing behind me.
And so that was not uncommon, right, for your boyfriend, who we've been together for many months, to approach you while you were asleep.
Well, no, that wouldn't be true either because my boyfriend never did anything like that, like while I was sleeping. Every time we've ever been sexual, it's always been consensual.
And I'm not talking about sexual, I'm just talking about approaching you at night. That's
Yeah.
not something,
It wouldn't be anything like that.
not him,
Yeah,
that's something that you guys.
yeah, it
Okay.
wouldn't be anything like that.
But you did believe at first that it was him.
When I opened my eyes, that was my first assumption before even turning around and seeing the father's face.
Do you recall before this happened that you walked outside to where?
Hey, pressure.
Yes.
Need to mess with this.
So I'll talk about the picture, obviously it can't display right now, but I'm referring to defense exhibit number 1, where there is a photograph of you sitting at the end of the table in front of the garage door. You recall that picture?
Yes,
So after you went to the bathroom and before this alleged incident took place, do you recall going outside one more time?
no, I don't recall.
Do you recall sitting at that same table in a disheveled, unkept manner?
No, I don't recall.
Okay. Do you recall people trying to speak with you while you were sitting at that table and you not responding?
No, I don't recall.
So that you don't have that memory of any of that happening.
No,
So you gave a couple statements to the police, right? There was, when the police first came out, there was your statement to the same nurse, is that correct?
Mhm.
And then later you went to the police department and gave a third statement. I think it was to a detective, correct?
I believe so, yeah.
So do you recall in at least 2 of those statements telling the police that you really weren't sure what happened?
No,
You never said that.
no. No, there's absolutely never been any question as to what I saw. Those memories are like permanently engraved in my brain.
You never use words like confused.
No, sir.
You never said that you were trying to remember if what you think happened actually happened.
No, sir.
So you testified earlier that you woke up to the feeling, or maybe it was your statement, to the feeling of someone lifting up your skirt.
I woke up due to actually feeling the penetration.
So you're saying that,
I didn't feel my skirt come up. I was still asleep.
so you said that your first sensation was sensation of your word being penetrated? Oh. And you didn't feel the skirt being lifted up.
I didn't.
You didn't feel yourself being uncovered.
No, sir.
And then you testified that you actually saw the defendant.
Correct.
And you testified that you saw him moving his hands.
Correct.
And I think you even motioned that he was withdrawing his hands to his sides.
Correct.
But would you agree with me that in the previous three statements that you made, you were unclear about what had penetrated you?
Unclear as in, did I see an object? No, I didn't see an object. However, the only thing that could have penetrated me would have been his hand.
So it's not that you saw his hands, it's that you assumed it was his hands. Is that correct?
If he's withdrawing his hands away from me, that would be the assumption,
Okay,
yes.
so it was an assumption. Now let's get back to your memory of you seeing him withdraw his hands. It's not until today that you ever told anybody from law enforcement in any of those interviews that you ever saw his hands.
That would be incorrect. I have spoke with someone. I wouldn't recall who exactly. I'm sure that it was probably with Marina, my DA.
But my question though is about the three statements you made around the time that this supposedly happened. My question is, did you ever mention seeing hands or the withdrawal of hands in those three statements?
I'm not positive. I've only heard one of my statements.
So you really have no way of disagreeing with me if I tell you that today is the first time you've done that. Right?
That's correct, if that's where you're going with that.
Is it also correct that when you initially gave the statement about what supposedly happened, that you told the police officer that you had been touched down there?
Like being in direct about, yeah. I mean, it's kind of hard sometimes to say those things, even though I'm an adult, it's not, it's uncomfortable.
But you're agreeing with me then that you use the words down there. Right?
I might have, I have only heard one of my statements, and when I listened to my statement with the detective, no, I actually used like the appropriate words.
And you did not use the words back there, you said down there, correct?
I'm not sure, I'm sorry.
And in fact, isn't it true that you later had to correct them because they assumed that you had been, because of your words, that it was your vagina that had been penetrated?
If
You
they
recall that?
assumed that, I wouldn't know. I imagine they would have asked for clarity, but this did take place 2 years ago, and so like the verbatim of what was said with the police, I wouldn't be able to recall.
And I'm not referring to your memory now. I'm talking about things that you said back then. And I guess my point is that I don't know if it was a miscommunication, but it's true that initially what you reported was a touching and then later a penetration of you down there. Is that correct?
I don't think my story has ever had any like differences. Regardless, it was me referring to being touched in my lower body, and it had always been anal penetration. I never said that he touched me vaginally.
No, I don't think that. That's why I keep using the words down there. And what you're saying today is that down there refers to everything below a certain area.
My lower body, yes.
Is that how you typically use that word, that phrase?
Yes, if I'm avoiding using certain words.
So at that point, you said that you made eye contact with the defendant. And you had assumed a bunch of things. But there was no talking, or no communication between.
There was no talking.
And you said that the door was wide open, right?
The door was open.
And what is directly across the hall from the room you were staying
At an angle, Kyle and Carol's room.
in? And then is there another bedroom in the near vicinity?
Yes, directly next door would be Benny and Layla's room.
And then where is the common bathroom with relationship to your door?
On my left side.
And that is the bathroom, the common bathroom that everybody was using that night,
Yes.
correct? And did you see anybody using that bathroom within 3 or 4 minutes before or after of what you say happened?
No. Because
Um,
after everything happened, and we did make eye contact, he did immediately turn around, walk out, turn off the light, close the door.
and that's what you remember.
That's exactly what I remember. Yes, sir.
So you mentioned that you stayed in the room for a few minutes, correct?
Correct.
And then you walked outside and you went and you sat at the table,
Correct.
at the party table where everybody was.
Mhm.
And that you were attempting to speak with your boyfriend at the time.
Correct.
Did you speak with anybody else?
Not until I came back inside.
Did you try to speak with anybody else?
No.
And this part is very important. At that moment, it seems like your boyfriend told you in a minute, we'll talk in a minute or something like that. Is that correct?
That is correct.
And then you went back inside?
Yeah.
Is that correct?
Yeah.
By yourself?
Yes.
And then that is when you ran into who?
Kyle.
Do you know what Kyle was doing inside the house?
Kyle was using his bathroom. He came out of his bedroom.
Was there anything strange about what Kyle was doing or what Kyle was saying or anything you observed about Kyle?
Well, Kyle was the first encounter that we had, I was already crying. I was already crying pretty uncontrollably. And Kyle had just said, what's wrong? And he had his hands and he was like, trying to slow me down. He was like, what's wrong? What's wrong? What's wrong? And I was like,
Well, and I'm not asking what he said. What I'm saying is there anything you observed about him?
No.
was notable?
he just came out of the bathroom.
Now, was Kyle drinking that night?
Kyle was drinking that night.
Was Kyle taking shots that night?
He was.
Was Carol drinking that night?
Yes.
Was Carol taking shots?
Yes.
When you testified earlier to this jury that you had seen Mr. Raimundo Perez's face, how long did you see his face?
For a few seconds, long enough for us to make direct eye contact, and both of us.
2 or 3 seconds, or if you remember what it was, if you don't, that's fine.
Yeah, roughly, I would say roughly about that. I mean, it was long enough for me to have lost my breath, and both of our faces kind of changed.
All right, so maybe 2 or 3 seconds.
Yeah.
So in the course of you're talking to the police officers, right? I'm sorry. You can take a moment.
Thank you. I'm sorry.
The police officers come in there and they're trying to help you, right? They're trying to take your information.
The day that they came, yeah.
Yes, ma'am.
Yeah.
And they're trying to collect evidence of what might be left over, right?
Uh-huh.
And they asked you if there had been any semen present. You know what semen is, right?
Correct.
It's human ejaculate from a male, right?
Mhm.
They asked you if any semen had been left, and I think your answer was that you weren't sure if it was. Do you recall that?
I don't recall that being my answer,
Okay.
but, okay.
Okay, and I guess what my point is if you were talking about somebody using their hand, you wouldn't expect there to be semen, right?
Correct.
But you didn't clarify that at the time.
I honestly just answered the best of my abilities. I mean, I had no idea what to expect. I didn't know if he was standing there prior doing anything to himself. Like when I had woken up, I genuinely had no idea what was going on. I just knew what had happened to me at that given time.
Okay, so you really weren't sure what had happened.
I was positive of the things that did happen. I was unsure of the things that could have gone on while I was asleep.
And at that time, you didn't mention hands either, right? You had seen hands or the movement of hands or the withdrawing of hands.
I don't recall what I said at that time. It's hard to recall the things regarding like the first conversations that I had with the police and such, because that was a very frantic moment for me. I
But
had a
just to be
hard time
clear, you
collecting
said
myself.
frantic, but it wasn't until 36 hours after this happened.
Emotionally, I was in a lot of distress though.
I got you.
Yeah.
So when you made this statement a day and a half later, you were no longer intoxicated, right?
Correct. I hadn't had anything after.
Very good. So, how old were you at the time, Bruce?
I was 22.
Very, very young, but I don't know if, do you ever watch any kind of true crime shows, any kind of Dateline, things of that nature?
Yes.
And so you know the importance, at least from a lay person's perspective, of preserving evidence, of saving things to be able to prove crime, correct?
Mhm.
And so in fact, you did save your clothes, right?
Yes.
And that clothes was turned over to the SAPD?
Yes.
Okay. And you also knew that it's probably not a good idea for you to shower or do anything like that, correct?
Yes.
And I'm not asking why, but you showered, but you say you didn't wash. Is
Yes.
that correct? Okay. Very good. You also mentioned that there was a hesitancy for a while you were in the bedroom because you were afraid of different things, right? But nobody in this case has ever threatened you.
No.
No one has ever put pressure on you to do things one way or the other.
No.
And I understand that the general fear that you're talking about, but I wanted to make it clear that there's no specific person that has made threats against you or anything like that.
No threats. No.
From now, with respect to what happened afterwards, it sounds like people at the party were trying to keep you isolated in your room. Is that correct?
That's correct.
So whatever may have happened outside, you weren't aware of any of that,
That's correct.
other than through what people may have told you.
That's correct.
And let's just say for the sake of your statement here, you told Kyle that you'd been touched, right?
That's correct.
But you didn't give him specifics.
No.
And then you didn't tell Ray anything.
Not until he came into the room.
And were you specific with him there then
Yes.
about exactly what happened?
Yes.
Within that 36-hour period, when the police officers were finally called, I'm sorry.
I'm sorry.
I'm so sorry. Need a minute?
I feel like I'm just gonna keep crying. I'm sorry. It's just it's hard to talk about. This is a hard situation.
Within that 36-hour period of time. The cops were called and they first responded to that house, right? And they came and they spoke with you on that day.
Yes.
And on that day, you were hesitant to file any charges, is that correct?
That is correct.
And it wasn't until after you spoke with your mother that you decided you needed to go forward with this, is that correct? I think that's what you said.
I talked with my mom. I did make the decision to go forward.
And what did your mom think?
My mom is Christy Salazar.
What did your mom do?
She's a paralegal.
And who does she work for?
Judge, I'm gonna object to the relevance.
Sustained.
I honestly don't know
Excuse
the
me.
name of the company.
Once I make a ruling, if you don't understand my ruling, just ask me.
Oh, yes.
So I sustain the objection, so you're not to answer that question.
I'm sorry.
Thank you. No problem.
Ask your next question.
But it was after consultation with your mother that you decided to press forward.
I wouldn't say I looked at it as like a consultation of like, what do I do next? It was more so like me confiding in my mother about what had happened. And she encouraged me to do what I thought was best for myself.
And you're testifying today that everything that you observed on that day was correct. Your contact did not affect you that day.
No, sir.
Your alcohol consumption did not affect you that day.
At the point in time of everything happening, you know, I won't try and say that it didn't affect me earlier at points in the night, but at that given moment, it was very, very point blank, very clear as to what I saw, what I experienced.
Your lack of sleep didn't affect your perception that day.
No, sir.
Your use of controlled substances did not affect your perception that day.
No, sir.
And while you admit that there are memories that you do not have today, you're saying that this is the memory that you do remember.
This is one thing that I will never be able to get out of my head, that I have had nightmares over multiple times. And one thing that tore apart my family that I will never be able to get back.
So let me ask you for a direct response. Is that a yes then?
This is-
Memory?
Yes, this is a memory that will not go away.
I'll pass it.
State.
Just have a few questions. Marita, I first want to talk with, do you remember the line of questioning concerning, has anybody threatened you or pressured you in relation to testifying in this case? Do you remember that question from Mr. Flores? But isn't it true that
Your
Mr.
Honor, may we approach Ron?
Yes.
Somebody said, isn't it true that the defendant's wife has asked you to drop charges?
This is correct.
Okay. I want to talk about, we spent some time talking about your contacts that we're in. I'm sure your optometrist would be upset with you. But did that change the fact that you slept with your contacts, your ability to see that it was the defendant who put his finger in your anus that night?
No.
While you were asleep?
No.
We spent some time, Marisa, talking about, you remember Mr. Floyd asking you about what is depicted in defense exhibit number 1. And that you said that you believe that this was a condom that you were blowing up
Yes.
because it was a, I think, to quote you, a dirty 30 party, right?
Yes.
Okay. So first of all, I'm sorry that I'm an older person, but I had to ask you what this came from, like, was social media. Do you remember that on a break?
Yes.
When you looked at this, were you able to tell what kind of social media this came from?
Yes, it's Snapchat.
Okay, and is this your Snapchat?
No,
Okay, do you know whose Snapchat this would come from?
honestly, no.
Okay, and I've never shown you this photo before, right?
Yeah, no, I didn't even know that that picture existed. Honestly, it's kind of
Me
funny.
either, so it makes 2 of us. I wanted to look at the timestamp here, or the date stamp here, and the timestamp. I can get it. That'd be a terrible news. So it's fair to say that that says October 10th, 2020 at 11:02 p.m.
Wow,
Can you see that,
I can see it up here. Okay, yeah.
right?
Uh-huh.
So that would have been before you went to sleep for the first time that night, right?
Yes.
I also want to look at the table, because you remember him asking questions like, oh, there were kids there, you might have been inappropriate, that's why they asked you to go to bed. You remember those
Yes.
questions? Okay. Well, first, let me ask you this question. Gee, I hope you did it. Way? That way. Okay. I'm not gonna move anymore. You count 5 beer cans on that table?
You would, I'm sorry?
Can you look at the picture, and is it fair to say there's about 5 beer cans?
Yeah.
Okay, and do you see what looked like right over here? Any of these items on the table, do those appear like anything that you remember seeing that night on the table?
Candy and maybe like any toys and stuff that they had made, like party favors.
Okay. During that night, because it was a dirty 30 party, was there anything else that was kind of around?
Yeah, there might have been like, maybe inappropriate candies and like, I think I want to say that there was even like little tiny lubes that we had got. Because Carol and I went to this bingo that's at a restaurant that like does this like a dirty bingo kind of thing. And they passed them out. They're friends with the owner of the restaurant.
Okay. You have any first witness?
Yes.
My name's I'm gonna show you. Show you what I'm marking as state's exhibit number 6 for identification purposes. Do you recognize that photo?
Yes,
Okay, so during the break, we talked a little bit, right? You went through your Snapchat as well.
Mhm.
We've never gone through your Snapchat before, right?
correct.
In response to viewing defendant's exhibit number 1. Were you able to pull pictures from your Snapchat of the party that night?
Correct, yes.
And what's depicted in state's exhibit number 6, a photograph of part of the party that night on October 10th of 2020.
Yes,
And what person is depicted in that photograph?
that's Kyle.
That's Kyle.
Mhm.
And does that photo truly and accurately represent Kyle and the cake that night on October 10th of 2020?
Yes.
And the cake that we're talking about is what's been marked as state's exhibit number 6 for identification purposes. What is that cake in the shape of?
It's a butt.
A butt. And is it clothed, unclothed?
It has underwear.
Okay. It's fair to say like a women's pair of like silk underwear.
Yeah,
And at the bottom of that photograph, do you recognize the head in that photograph?
that looks like Benny.
And Benny is how old?
At the time, I think he's 8 now, so maybe like 6.
Okay,
Ish.
so you got a 6-year-old looking at a dirty 30 cake, right?
Yes,
Okay. Also during the break, you were able to look at, there's videos on that you had on your Snapchat, right?
yes.
I'm gonna show you what I'm marking in state's exhibit number 7 for identification purposes. Do you recognize the disc?
Yes,
And how do you recognize it?
because I initialed and dated it.
And again, are these videos from October 10th of 2020?
Yes,
You know, the party that night.
yes,
And it's fair to say, we've never talked about this before until we saw defendant's exhibit number 1, right?
correct.
Okay. And so, were you able to view, how many videos are on the disc?
2.
And what do they generally depict?
The whole party scene, I guess.
Okay. Does it also include videos that show you?
I'm gonna object to relevance and leading witness.
Objection to leading is sustained.
Okay. As far as state's exhibit number 7 is concerned, generally, what do the photo or the videos depict?
One is Kyle having his face pushed into the butt cake, and the other is all pretty much the whole scene of everything, but all the children, the amount of children, I guess, that were there.
Okay, and the butt cake that you referred to, is that?
I'm gonna object to the line of questioning. They're referring to things they're not admitted in.
All right. That'll be overruled. You can ask the question.
Thank you.
She can be a little closer to the microphone, interpret what it's saying.
Thank you. Everyone, please make sure you keep your voices up.
Yes,
Yes, ma'am.
the butt cake that's in the videos in state's exhibit number, or what's been marked as state's exhibit number 7, is that the same butt cake that's in state's exhibit number 6?
Yes,
Your Honor, at this time, state would move to state's exhibit number 6 and 7. Previously tendered them at break to Mr. Flores, and I'm giving to him for inspection.
Your Honor, I'm not gonna object to number 6. I will object to number 7 as being irrelevant, I'm sorry. I believe whatever is trying to convey sufficiently dealt with exhibit 6. Anything else beyond that is duplicative.
All right. State's exhibit number 6 is admitted without objection. With regards to state's exhibit number 7, the court has not viewed state's exhibit number 7.
As a matter of moving,
I'm sorry, the court has not viewed state's exhibit number 7.
yes, and as a matter of just moving this along, at a break, can we have the court review it, make a ruling, and if it's admissible at that time, then we can display for the jury.
All right. Defense, do you have any objection to the court not making a ruling on 7 at this time?
No, Judge, I think that's perfect.
All right. You may proceed.
Good. You may publish it.
Yes.
So I'm gonna show you what's now been admitted. It states exhibit number 6. So we can see, you said that this person, it's Kyle, right?
Correct.
And then. This is the butt cake we're talking about, right?
Yes.
And then we have the child, the 6-year-old down here, right?
Yes.
Okay. So it's fair to say that, well, I shouldn't say that. Was this, what's shown and depicted in state's exhibit number 6, pretty consistent with the theme of Dirty 30 that night?
Yes.
The other items that were there that night?
Yes.
Then I want to talk about just generally the time frame of the actual sexual assault. So about how long would it say from the time that you woke up because you felt the penetration of your anus to the defendant walking out the door? How long would you say that that was?
I felt him for a couple seconds. It took me a second, I would say, to like wake up and fully recognize everything. So I do remember like having a full visual of staring at the white blank wall for a second and like recognizing, wait, I feel something. And I turned around and that's when I see his face. Altogether, I feel like our encounter couldn't have lasted maybe more than a minute. But there was enough time for both of us to make direct eye contact and enough time for me to like kind of just sit and be taken back for a second. Like it wasn't like a super fast thing to where I couldn't have remembered.
What do you say, no more than a minute?
Yeah.
So for somebody, in order to see this, would have had to have come by the room within that 1 minute period of time.
Yes.
Just one moment. Your Honor. Last thing I want to talk about is, you remember Mr. Flores asking you questions about basically the nature of the importance of preserving evidence, right?
Yes.
And it asked you about shouting.
Yes.
Were you trying to wash away any potential evidence, scientific, biological, whatever it may be, when you sat in the shower?
No.
Why were you in the shower?
I wanted to get away from everybody. I wanted a second to just sit and I wanted to have a moment to kind of just process everything that I experienced. And now that my fiance knew it, I had instant feelings of being unworthy because his father touched me. I felt like I wasn't good enough for him. And
This is not responsive to the question asked.
Sustained.
So, also just one more thing. When Mr. Flores asked you, since the time when you met with the initial officer, you gave him just a very brief statement. You described the defendant touching you down there. Do you remember him asking you those questions?
I remember them questioning me. I don't remember what.
And that's the poorly worded question. Do you remember Mr. Flores asking you this question?
Oh, yes.
When you said down there, by down there, what did you mean at that time?
I meant my anus. I meant I was directing to my anus. Just I guess I didn't want to use the word.
Did you ever tell the officer that it was your vagina?
No.
Or another word that you might use for your vagina?
No.
Bishop has the-
Defense.
Yes, just a few questions. So I think we have a little bit of clarity now. So now we're admitting that we potentially could have used the words down there. Is that correct?
Yes.
But you're just clarifying it now and
Yes.
saying that what you really meant was anything below your, under your waist, maybe. I don't know what that was your mouth. That you meant, you were referring to a general area.
Yes.
So, but those were clearly the words you used.
If that's what was in the statement, I personally don't know what I said.
You don't recall.
I don't recall.
Okay.
Sorry.
So we understand now, whether we did then, but we understand now the importance of the preservation of evidence, right? Maintaining things in a certain way so they can be later tested and reviewed by for lack of a better term, the CSI people, the people that analyze for DNA, for, you know, things of that nature. That's right.
Mhm.
From the moment that you're saying this happened to the moment that you went to the same nurse, who was the hospital and the nurse, where you say that they photographed you and took samples of you, is that correct?
Yes.
Well, let's go back to that a little bit. So when you went to the same nurse, in addition to photographs, they actually took swabs and samples of your body, is that correct?
Yes.
And they were looking for substances, possible DNA on your body, is that correct?
They were looking for everything, anything they could find. Yeah.
And did they also they didn't limit themselves to the parts that you told them, is that correct?
That's correct. They
checked
looked
everything.
everywhere. Yes.
So whether you had said down there or back there or whatever, as far as they were concerned, they checked you for everything, is that correct?
Yes.
And you also turned over the clothes that you were wearing on the night that this happened, is that correct?
Yes, I turned those into the police.
And you sure you turned in the correct clothes?
Positive.
So now maybe because of this process and maybe because of your prior knowledge, you know the things that may distort those exams, right?
For the most part, yeah.
Did you do anything from the period of time that this alleged incident happened to the same nurse exam that might have skewed that testing or those exams on you?
Judge, I'm gonna object. It calls for an expert opinion.
The question is
No,
about
that'll be
her actions.
overruled if you know.
To the best of my knowledge, no, I didn't do anything to alter it. I actually don't think I was even able to use the bathroom for the first few days because I was just uncomfortable.
So when you testified earlier that you had gone to the bathroom, you were referring to what?
When I had gone to the bathroom, the last time I had gone to the bathroom was prior to everything happening. So I hadn't like gone to the bathroom after like peeing. I hadn't had any movements since.
Okay, there we go.
Yeah.
And I kind of knew what you're talking about, but I want you to clarify for the jury.
Yeah.
So you had urinated, right?
After,
Yes,
no, I like didn't use the bathroom at all. Like
for 36 hours.
for a few days. Yeah.
Fair enough. And so presumably when you went to the same nurse exam, other than running shower over your head, you hadn't done anything to alter the state of your body.
No, actually, after I had changed out of my clothes, I remained in those same clothes for probably the next 3 or 4 days.
I have no further questions. I'll pass it. This.
I have no further questions.
All right. Is this witness excused or subject for recall?
She's subject for recall, Your Honor, please.
All right, the rule has been invoked. You're not allowed to speak to anyone except for attorneys for the state or attorneys for the defense. Just make sure you're available if anyone wants to recall you.
Yes, ma'am.
Thank you. You can step down.
State, call your next witness.
They call Shannon Murphy.
Yes. All right, could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can have a seat. Make sure you keep your voice up so that the court reporter can hear and that the interpreter can hear. If you could state your name for the record and please spell it.
Shannon Murphy, SHANNON
State.
Thank you, Your Honor. Ms. Murphy, how are you currently employed?
I am currently a full-time sexual assault nurse examiner at Methodist Specialty and Transplant Emergency Department.
Okay, and do you have another part-time job?
I do, yes.
Okay. And where do you work part-time?
I work at one of the freestanding ERs in Bulverde.
Fair to say you're a busy woman.
I'm a very busy woman, yes,
In fact, you have to work tonight.
I do,
Is that why you're in strike?
yes.
What time do you have to work tonight?
7 p.m.
To
7 a.m.
all of us. So how long have you been, when you say the sexual assault nurse examiner, I'm gonna use the word SANE.
Okay.
For abbreviation, that's okay. How long have you been a SANE nurse?
Since 2007.
So what are the steps to become a SANE nurse?
Okay, so most SANE nurses have to have been a registered nurse in the state of Texas for at least 2 years and have to have some sort of trauma experience, either working in an ICU or an ER. Then you go through a classroom training with the Texas Attorney General's office. Then I went and trained with a gynecologist doing well woman exams, learning how to identify female genital trauma from normal. We do courtroom testimony training, and then I have to do 8 sexual assault kits with a preceptor. Once you get all that collected, then you're certified.
Okay, so that's just really even after you become a nurse.
Oh, yes.
Right? So what are the steps to become an RN? And let's say in your case, how did you become an RN?
I went to nursing school and I passed, and then I took my state boards and I passed.
Okay, is that a bachelor's degree?
Yes.
So I want to talk just kind of very broadly and generally about these types of examinations,
Okay.
not specific to this case, okay? So what is your goal in doing a sexual assault examination?
So as the sexual assault nurse, our ultimate goal is medical history and diagnosis. We're doing this exam to make sure that the patient is physically and medically okay, to make sure there's no needs that we need to address, such as STD or pregnancy prophylaxis, any lab work, any trauma or injury we need to take care of. And then secondary to that, we assess to see if there's a potential to collect DNA off of the body based on the history. And if so, then we do that as well.
Okay, so let's just generally talk about like a step-by-step process in a general way, how you do these examinations. So what's the first step if somebody presents themselves to the ER or to that is special clients for a CME?
So the first step is we actually have our patients go through the ER first. They go through a triage process with the ER physician. The physician makes sure that there are no injuries or trauma or lab work that's needed that's beyond the scope of my practice that needs a doctor involved. They also offer the patient STD and pregnancy treatment at that time if they so desire.
Okay, so they go through the ER first.
Yes.
So once they're done with the ER, what's the next step in the process?
They're released to me. My first step in my process is to get a complete history of what happened, including a little bit of a medical history and background and a history of behaviors that the patient has engaged in since the assault that might alter the collection of DNA evidence.
I get in a little trouble sometimes talking about histories versus histories, right? There's a medical history that you take, right?
I take a forensic history.
Okay, which is what happened to them, right? Reading it the
Their verbatim statement of what happened to them that brought them to me that evening or day.
So that's the forensic history, right?
Yes.
Is it also fair to say you take a medical history that's in general?
It's a medical, yes, it's a medical forensic history.
Okay.
Yes.
So after you've taken their history, what is the next step in the process?
So the next step is we do the physical exam. So I start with we get the patient in a gown and I do a complete head to toe physical. I'm assessing for injury and trauma and anywhere in the history that indicates DNA may still be on the body. I then try to collect that DNA.
Fair to say before you do any part of the physical examination, you're going to get consent from the patient, right?
Consent and assent are ongoing throughout the exam. Not only do we provide informed consent about the risks and benefits of the exam and what we do, it's up to the patient to assent throughout the exam. They're constantly saying, yes, you may do this, or no, you may not do this.
So once you do a physical examination, as well as potentially take any potential DNA, or not DNA, but let's say scientific evidence, what's the next part of the examination?
Then I do, then if the assault occurred in the vaginal or anal or penile area, then we do a detailed anogenital exam. Again, assessing for injury or trauma, making sure everything is medically okay. And then swabbing for DNA or scientific evidence if the history warranted that.
So like a genital exam.
Correct.
And anal, depending on what the history tells.
Correct.
And then is there a next step in the process?
The next step is discharge. We discharge the patient with referrals, follow-up. It's sort of tailored to the patient, whatever their needs may be. Give them information how to follow up with law enforcement and then get them out of there.
About, if you know, do you know how many sane, and I know sane exams is redundant, but how many sane exams you have?
Yeah, I think my totals at the end of 2022 were just over 2,000 exams.
And that's since 2007?
Yes.
I want to direct your attention specifically to an examination regarding a patient by the name of Marisa Salazar. Were you able to review your records as it relates to that examination?
I did briefly, yes.
Your Honor, may I approach?
Yes.
I'm showing you what's been marked as State's Exhibit number 8 for identification purposes. Is this your sane records as it relates to Marisa Salazar?
Yes.
Okay. And when did you complete your examination on Ms. Salazar?
When did I complete it? Or
Or I should say, when was the examination?
examination? It was on the 12th, and it looks like I started at 9:45 or 9:48 PM. Sorry, I don't have my glasses. I forgot them.
Okay, October 12th.
Yes.
And you are at this time, state moves exhibit, state exhibit number 8, and I believe based on the agreement of parties, the version of state exhibit number 8.
I previously reviewed that, Your Honor. I have no objections.
All right, state's exhibit number 8 is admitted without objection.
Ms. Murphy, hold on, let you hold on to state's exhibit number 8 if you need to refer to it during any part of the question, okay? So as it relates to Marisa Salazar, what type of sexual contact did she report to you?
She reported that she awoke with pain in her genital area. But she sort of answered unknown as to any specific penetration of any one area.
Um, I'm gonna show you specifically on next exhibit number 8. And hopefully this refreshes your memory. I'll try to. So specifically, she states my anal area was hurting, correct?
Yes,
So she did identify pain to her anal,
anal area.
right? And then right here says. Where are you? I will. Where are you? There. Where it says, I woke more to feeling pain in my anal area. You see that?
Yes,
Okay. So is it fair to say she did identify her anus as the area that?
yes, yes.
Okay, not just broadly her genitals, right? So based on that history, did you do an examination of her anal area and her anus specifically?
Yes.
When you're doing that for what she's alleging, some type of anal contact, what are you looking for in that anal examination?
First, I'm swabbing to see if there's the potential to pick up any scientific evidence. I'm also evaluating for injury or trauma that we may need to photo document.
In this case, when you did her anal examination, and I'll give you your records back. Did you note anything related to that examination as it might relate to potential evidence of trauma?
Just that she made the subjective statement that it hurt in that area. I did see a little redness in the area,
Okay.
but no trauma.
Now redness and I think y'all call it point tenderness.
Mhm.
That subjective, it hurts when you touch there, right?
That's the patient's subjective report that it hurts when we touch there, or
Um,
that it hurts in general in that area.
Is that consistent with somebody who is alleging digital anal penetration?
It certainly could be.
Okay. And in the scientific and medical community, we could use, definitely not in that community. Use terms like consistent, right? What does that mean?
It means that certainly the redness could be from some sort of penetrating or blunt force trauma, but it could also be, redness is a not very specific diagnosis. So it can be from a medical condition. It can be from not cleaning yourself well. There's a lot of redness in and of itself is not confirmatory of trauma.
And as it relates to general, these findings during sexual assault examinations, is it common or uncommon to have these types of consistent findings?
Objection, Your Honor, relevance to this case.
That'll be overruled.
You can ask that question.
Can you rephrase that a little bit for me?
Sure. So you've done approximately 2,000, right?
Yes.
Do you normally find trauma that is specific to some type of sexual assault or sexual trauma?
We find trauma related to sexual assault, both in the vaginal and the anal area, very infrequently. Yeah.
So it's not very often you find specific trauma, right?
Correct.
And as it relates to like a digital anal penetration, why is that?
A lot of factors. So trauma is based on one object coming into contact with another object. We don't know how lubricated that object is. We don't know at what angle that object came in. We don't, if we're not there, we don't know the dynamics of the contact. So some trauma and contact just does not leave injury. I can fall down the stairs and I don't end up with a bruise.
As it relates to the anus specifically, anatomically is the reason that sometimes there aren't injuries on a penetration case.
The anus is two sphincter muscles, one on the inside and one on the outside. Certainly, if there are a host of conditions that can make that area easy to penetrate without causing injury, the person can be sedated. That muscle like relaxes. People can be asleep and that muscle relaxes, intoxicated, under the influence of something. There's a whole slew of reasons why you could penetrate that orifice and not necessarily see an injury.
Okay, let's talk about, I think, two that you mentioned. So you said if somebody is asleep or unconscious, that muscle relaxes.
The muscle is relaxed, yes.
If somebody is intoxicated, that muscle relaxes.
Intoxication causes all of our smooth muscle system to relax.
And so that's why those are two factors that might lead to the fact that there is no trauma.
Correct.
As far as evidence collection is concerned, are there specific, I don't want to use the word like mechanisms of like penetration or contact that lend themselves more or less to scientific evidence of DNA being available?
Certainly. So the behaviors you engage in after an assault, whether you've showered or bathed or gone to the bathroom, or those can affect the collection of DNA. Time can affect the collection of DNA. We know that a human body is a moving crime scene, basically. So you're losing DNA every time you eat, move, go to the bathroom, do all those things. So time is a factor. Sometimes we're only able to get, oral DNA up to 24 hours. We're only able to get certain touch DNA up to 48, 72 hours. So time, behaviors, those can all affect.
And let's talk specifically to the allegations in this case, that digital anal penetration. In your history, training, experience, as a sane nurse, you think it would be common or uncommon to find DNA in a case like that?
In a case like this, at the time frame that the patient presented, and if it was only touch DNA, it'd be very hard to get.
Let's say she immediately went. It might increase the ability to, but even in those types of cases, would you expect always to find DNA?
In any case, I never expect to find DNA. We try and we hope, but
Does the absence of DNA prove that something didn't happen?
no.
So as far as this case is concerned, the specific, I don't want to use the word specific, but the findings that you found that were relevant to the history of a digital anal penetration would be the point of tenderness and as well as the reference.
Yeah.
Yes, as well as the history she gave.
Correct.
Judge, at this time, I will pass the witness.
Defense.
Nurse Murphy, good afternoon.
Good afternoon.
My name is Albert Flores. I represent Mr. Perez in this case. If you don't understand something, please ask me to repeat it. Nurse Murphy, just because I'm assuming that a lot of the jurors have never heard of your profession before. But aside from the training, aside from the academic qualifications, do you also get any type of sensitivity training, type of training where you could be an advocate for the person that comes to see you?
Yeah, in our continuing education, we get a little bit of that.
And what that means is basically you were there to provide a service to somebody that may be in a traumatic situation, right?
Correct.
It's not your job to question the veracity of what they're telling you, the truth, the lies of what they're saying, correct?
Correct.
You just are basically there to document whatever comes out of their mouth.
Correct.
Okay? You were not an investigator. You do not do your own analysis and investigation about what happened prior to that person arriving in their ER, is that correct?
Correct.
And so if somebody tells you, a certain thing happened in Houston, you write down it happened in Houston.
Correct.
And whether it happened in Houston or not, you would have no way of knowing.
Correct.
And so a lot of your analysis depends on what the complaining witness tells you, correct?
Absolutely.
You have no independent knowledge and no verification whether what they're telling you is true or not.
Correct.
And this goes back to your job as just kind of observing, collecting, and reporting what you've seen.
Correct.
So you testified that that the first part of the process is when somebody comes in making a complaint of sexual assault, they're sent to triage, right?
Yes.
And triage would take care of larger medical issues other than the sexual assault, is that correct?
Correct. Yes. Life and limb always over forensic.
Okay, maybe somebody got beat up in the process of being raped or stabbed or shot or something like that.
You got it.
And that's what that triage is, right?
Yes.
And in this case, there was none of that.
Yes.
And I think that the prosecutor also asked you that there were certain behaviors that might alter the findings that you make when you're examining a particular patient. That's correct?
Correct.
And sometimes that could be time.
Time.
Okay, so in this case, I believe that the time was 38 hours, and that's certainly within that 48-hour window that you're looking for DNA. Is that correct?
We can do DNA collection up to 120 hours.
See, you seem to say that the sweet
Right. So
spot is somewhere between 0 and 72 hours.
depending on the type of DNA you're looking for, is it semen DNA? Is it saliva DNA? Is it touch DNA? which orifice are we looking at? They all have sort of predictable timeframes, although those are not absolute.
And would you say that 36 hours or 38 hours is within that time frame?
I would say that that's kind of for, what kind of DNA are we talking about?
What were the choices?
I would say for touch DNA, that's pushing it, like you're pretty far out. For semen DNA, that'd be a great time frame. So,
Now, with respect to, and that's something you've been told, right?
correct, that's in our training.
And so maybe the person that analyzes the DNA would have a better opinion of that than you?
Certainly.
All right, so what you're relaying to us is what somebody has told you about this particular.
Is our education generally on how long DNA lasts on the body.
Okay,
Yes.
Very good, very good. Now, Mr. Villarreal was asking you initially if it had been reported what type of I don't remember, you said what type or what was the area that was penetrated? And initially you said it was reported as unknown.
Correct.
And why did you say that?
So in my history, we have a table that's actually on page 2 of 6 of the section.
If I may,
Can I just ask that y'all speak on this? We don't are in the process.
may I approach, Robert?
Yes.
I'm gonna borrow that from you and then hopefully the magnification will help both of us. May I, Your Honor?
Yes.
Right. So I placed what was previously marked as State's Exhibit number 8, and this is the report that you created in the course of investigating this case. Is that correct?
Correct.
Okay, and if I'm really terrible at this, but if I'm reading what you say correctly, the table you're referring to is the one I'm circling with my pen here.
You are correct.
Okay, and explain to us why. Number one, why your testimony was that initially that you had unknown. And why is your chart marked that way as unknown?
Okay, so when we ask these questions on this chart, this is asking the patient, do you know with 100% accuracy if your anal area, your oral area, or your vaginal area were penetrated with what and by what? So,
And let me stop you there.
Okay.
So do you know with 100% accuracy, and this is a question that's directed to the patient, right?
yes,
Okay, and whatever they respond is what you got on the chart.
correct.
And in this case, did you go through every specific one
Always.
individually? And forgive me, and I'm gonna have you educate us on this, but when you refer to vulva, what does that mean
That's your whole external vaginal area
for a female?
for a female.
Okay, and when you asked her if she had been penetrated in the vulva all the way across, what was her answer?
I don't know.
Okay. And when you asked her the same question, do you know which one of these objects penetrated you in the vulva? What was her answer?
I don't know.
And the same question with the anus. When you asked her if she knows whether the anus was penetrated, what was her answer?
I don't know.
And when you asked her of these 4 objects were you penetrated in the anus, what was her answer?
I don't know.
And then the same thing with the mouth.
Correct.
And so when you testified earlier that your notation for what caused the potential trauma at the initial statement, your answer was, I don't know. Her initial answer was, I don't know.
Correct.
Okay, and that is in response to the question of 100%. Is that correct?
Correct.
And so later on, you get a narrative from them, right?
Yep.
And that narrative is their version of what may or may not have happened.
Correct.
And that is the first time that you hear about pain in her anus.
Yes.
Correct? Now, she doesn't tell you that she was penetrated in the anus.
No.
Okay, so she never, ever, ever said that she was penetrated in the anus
Correct.
because you would have noted it in the first chart.
Correct.
What she did say was that I have pain in my anus.
Correct.
And it seems to me, based on your chart here, that it was undetermined why she had pain. Is that correct?
Correct.
With respect to behaviors that may alter your findings. Okay, and you mentioned some of those was time, we talked about that a little bit. You mentioned that the other one was potentially washing the area. Okay. And in this situation, she mentioned she showered, right? And you noted that on,
Yes.
but you also noted on there that she had not bathed.
So we draw a difference between a shower and a bath. A bath is a soaking and a shower is standing under a shower head.
Okay. So if somebody showered, and I guess that I'll start by saying this, would you agree that with that not all showers are the same?
Correct.
If somebody showered and used no soap and did not scrub the affected area, would that have a higher probability of collecting evidence or having evidence collected for you?
Good.
It could,
Good.
okay. So you have no way of determining one way or the other.
Correct.
It would just be logic, if there is that logic, right?
Just sort of be,
Okay, so there's no special answer to that other than use your logic, I guess.
yes.
With respect to there's a question on page 1 of 6. And it's subsection 2B. So it seems like you go through a series of questions and you check off whether they respond yes or no. Is that correct?
Correct.
And did you develop this form?
No.
Okay, so can we assume that this form was developed to get that information that is most important for the case?
Judge, I'm gonna object to speculation.
That'll be sustained.
Somebody else, well, do you know who created the form?
No.
But it's certainly the form that's been used for how long since you've been doing this?
For years.
And the first question, actually, they're just questions that it appears to me that might or might not help you. Determine the quality of whatever evidence you might collect. Is that correct?
Judge, I'm gonna object to essentially the sidebar. If it appears to me or it surmises to me, it's not relevant with the defense counsel.
Let me rephrase, Your Honor. What are those questions? Why do you ask those questions?
Those are behaviors that we want to know if the patient has engaged in prior to the examination, because they could alter the collection of DNA.
Okay, and those are the questions where I asked you if she had showered and she answered yes.
Correct.
And you asked her if she had defecated, which is, I mean, you can use a bunch of terms, had a bowel movement, go on number 2, that's all defecated, correct?
Correct.
And she answered no.
Correct.
Okay. But when you asked her if she had urinated, she said yes.
Yes.
And then we jump down to subsection number 3, let me scoot it up a little bit. There is a question, the second question on there that says amnesia period, use of drug or alcohol. What does that mean?
So that is specific to if you were blacked out due to intoxication or drugs.
Okay, so it's not about the use of drugs, it's whether somebody was intoxicated, or could it be both things?
It's more specific to if you were rendered unconscious, so to speak, by it. I mean, people can have a drink or two, and they're not,
Correct, correct.
blacked out.
But with respect to her understanding whether she was passed out or not, she's saying no.
She, in the report, she said she went to sleep. She didn't indicate she was intoxicated.
And again, whatever she tells you.
Is what I-
Right on.
Correct.
You have no independent knowledge of anything otherwise.
Right.
Now, there's a second page, the page after that, page 2, is where you note the redness on her body.
Mhm.
Now, you have, it seemed to me from your testimony that you have a couple of options. Right? Is that correct? You could have noted trauma,
If I saw trauma, I would know trauma.
and that's what I mean, I guess, in the scale of things, trauma is more serious than redness. as I understood.
In the scale of things, I note what I see. So I wouldn't actually even probably call it trauma. I would say a cut or a tear or a laceration or redness or bruising. So I would describe what I see.
Were there any cuts? Were there any tears?
No,
Were there any fingernail markings, anything like that?
no,
Okay. Any bleeding?
nope,
And in fact, I think you testified that the redness that was associated with it, it was kind of undeterminative of where it came from.
correct.
In fact, you testified that it could have come from somebody potentially not cleaning themselves for
Yes,
a period of time.
redness is very general.
It's not bruising,
It's not bruising.
not bleeding.
It's not broken blood vessels under the skin. It's not a tear or a cut in the skin.
Very good. So broken blood vessels would be something maybe with a bit more of an impact. Is that right?
Right, that would indicate some sort of trauma to the area.
We didn't have that in this case.
Yeah.
And would time affect that?
Absolutely. That area of our body, our genital area is mucous membrane, and that heals much quicker than skin.
Okay, so whatever you saw, whatever redness you saw on a day, would have been 10 hours old.
Yeah, it would more, it could be less than it was at the time. It could be more than it was at the time.
And you have no way of knowing one way or the other.
No,
Now, with respect to the samples that were taken, you did take a sample of the vulva area.
yes,
You did take a sample of the anal area.
yes,
Are you pretty thorough in doing that?
yes.
And if someone were to tell you, hey, with respect to the anal area, nothing has touched it in 36 hours, there have been no bathrooms, no bowel movements in the last 36 hours, would that be more helpful or less helpful in determining whether your sample would be good or bad?
Obviously, the less of those behaviors that we engage in that can tamper with DNA that you do, then hopefully the more likely we are to get a DNA collection.
Great. What happens with those DNA swabs once you take them?
Once I take them, I insert them into a drying box. Once I,
Let me get you to be more specific. When you take a sample, we've seen it done on TV, but I don't know if that's how it's done in real life. How would a sample be taken? Because a brief synopsis.
so it depends on the part of the body. We go by Texas evidence protocol on how to collect these samples and with throughput from our local crime lab. So for an anal swab, I would take 2 swabs. I would lightly wet one swab with some saline. And then we would swab the external anal area in between the folds and just sort of hold the swabs right in the opening of the anal area for a second or 2.
And then what would you do with that swab?
Then I would take those 2 swabs. We are provided in our evidence collection kits with drying boxes because the swabs are moist. They put them directly into the box, and that's where they stay until the crime lab processes them.
Okay, so there's no processing in that hospital where you work?
No.
So that is sent off and submitted to some sort of DNA analyst or?
So generally, the law enforcement agency that's involved will come and take custody of the kit. And then it's up to them to send it off to the crime lab that they use for analysis.
Are you the one that types out the narrative?
Yes.
So do you see in the narrative? You don't have it, do you? Is it better to read it there or?
No,
would
that's
you prefer
perfect.
it? Okay. So do you see in the narrative, and again, this is you typing whatever her words are.
Correct.
Correct. When I say her, it is the report for one Marissa Salazar. Correct.
Yes.
And there's a right about the middle of the paragraph. It says around 3:30 a.m. my boyfriend came in to check on me. I was in the bathroom and he helped me back into bed and covered me again and closed the door. If it's in the report, those are words that came out of her mouth,
Correct.
not something you made up.
No.
I'll pass the witness.
State.
A couple more questions, Judge. Ms. Murphy, I want to talk about, spend some time on the boxes, which I'll show you on top there. And then we spent, the last thing that Mr. Flores went over with you is the history. The narrative portion of the history. Which of these do you go over first?
The boxes.
The boxes, okay. So, Mr. Flores asked you, you're not an investigator, right?
No.
So if you go, are you 100% sure if you were digitally penetrated? She said, I don't know. You're not asking her, why don't you know, right?
Correct.
Did you ask her, did you see the defendant's hands?
No.
Did you ask her about follow-up questions to make a determination if you could figure those out based on her memory and recollection of what happened?
No.
Okay. So the fact that it's unknown, that's just an initial response, right?
Yes, that's a response of. If I knew a penis went in my vagina, I would say, yes, penis went in my vagina. If I woke up and I just had pain, but I wasn't sure what happened, I'd have to say, I don't know.
Right, and so you're not asking follow-up questions, right?
No.
That's an interpretation of basically, I don't know, right? So could it be that I'm asleep? I don't know if he did any of those things?
Your Honor, I'm going to object to the question asked for speculation.
Sustained.
And let me ask it this way. He was really clear about saying, well, she said, I don't know, I don't know. That's not what she said necessarily, right?
She said she didn't know if a penis had penetrated her vagina. She didn't know if a finger had penetrated her vagina. Like,
You don't ask why though, right?
no,
Okay. So you're not asking specific questions about the facts that happened that night to hopefully reach a better conclusion of what
no,
those acts might be, right?
right,
Because you're not an investigator. right?
correct,
So your purpose is medical treatment and diagnosis.
correct.
So it's fair to say that if law enforcement gets additional statements, if they're able to talk to her, she might be able to figure those things out.
Your Honor, I'm going to object. It's asking for speculation from the witness.
Sustained.
So going through her narrative, and I want to go through this a little bit. So. Hopefully this will let me mark. As I woke more to the feeling. Of pain in my anal area, right?
Yes,
Based on that statement, you couldn't put a check on your box, right? On that little check things, right?
correct, because pain and penetration are two different things.
But this surely indicates to you some type of contact to her anal area, right?
What this indicates to me is that she's having pain in her anal area.
Okay. My anal area was hurting and I was trying to put it together. That doesn't necessarily indicate to you on a medical perspective that there was at least some sexual contact to her anal area.
What it indicated to me in a medical forensic history is that I need to check that area to make sure it's okay. Secondary evidence collection, but no, I cannot infer that that means actual penetration.
And I'm asking about contact.
I can't infer contact either.
Okay. So. Granted, you're looking at this from a medical perspective.
Correct,
You're not looking at it to make a determination from a law enforcement. perspective.
correct.
And again, she says, my skirt was lifted and my bodysuit pulled aside and the blanket was down. So indicates to clearly indicating that her clothing was different from when she went to bed.
That's what she is stating.
Yes. As far as when you met with her and her demeanor, what did you note her demeanor as?
That she was tearful.
Was she cooperative?
Yes,
And I know you have to, and I'm sure you do this in the least traumatic way as possible. But generally speaking, in your history, are these examinations comfortable for people who are coming and presenting for a sexual assault?
I would think they are not. They're long, they're drawn out and a little invasive.
I'll pass it.
Defense.
Just a few questions, John. Nurse Murphy, you testified earlier, and I hadn't asked you about this. In response to Mr. Villarreal's questions, that potentially there were some things that might affect how hard it is to penetrate certain parts of the body. Potentially alcohol, potentially somebody being asleep. Is that correct?
That affect the muscle,
The muscle.
not the potential to
Okay.
penetrate.
That's
Yeah,
all you're saying.
yeah, yeah.
right?
Yeah.
And it's not something you've tested yourself?
No.
It's not something that your hospital has tested?
No.
Okay, that's just information that you received in your training.
Oh, that's common medical knowledge. Any kind of vasodilating or depressive medication or alcohol causes smooth muscle to relax.
And does it happen in every single case?
I guess it just depends how intoxicated or what somebody is under the influence of.
And you don't have that information for this case?
No.
So you can't make a determination in this case?
No.
I'll pass it to you.
Um, One brief question, just line of question. As far as the difference between bathing and showering, do you make that distinction to them when you're asking them?
Absolutely.
So if they had told you, I sat down in the shower while the shower was running, would you have marked that bathing or showering? Or
I
both?
probably would have remarked both. Yeah.
I'll pass it.
No further questions from us.
All right, is this witness excused or subject for recall?
She's excused from state perspective.
She's excused from the defense perspective.
All right, you're excused. The rule has been invoked. That means that you can't discuss your testimony with anyone. The only persons you can speak to are attorneys for the state or the defense. All right, thank you. You can step down. Ladies and gentlemen, we're going to take a short break so we can change out the interpreters, and I need to take care of a matter that's unrelated to this case. Remember, you've heard some evidence in this case. You're not allowed to discuss it amongst yourselves. You're not allowed to start thinking about it or deliberating. The court will let you know when it's time to deliberate. Do not do any investigation work. Do not look at anything. If you see something or anyone gives you something, completely ignore it. Okay? All right, everyone, please rise for the jurors. David.
We have a moment to step out, Judge?
Sure. Has your case been done? I mean, have you done all the paperwork? All right, so if you'll go in the back and have Caroline just bring it to me, we'll take it up at that. We'll do it right now. Ah, she's here. David. I call her name and she called. Sure.
And another interpreter will be.
All right, thank you so much. Do we need to call for another interpreter or they know to come down?
We know that the.
All right, thank you. All right, he's pleading to 2 cases, correct?
That's correct, Judge.
This is me.
All right. Could I have someone from the state? Michael, are you able to do this, please?
I can say safety exhibit 1, Judge.
Thank you. All right, court is calling 2023 CR 0463W and 2020 CR 2998, State of Texas versus Adrian Soto. Could I have parties announced for the record for the state
Michael Villarreal, please.
defense?
David Andre Woodard for Mr. Soto.
All right, in each of the cases, counsel, have you received all the discovery and did you review it with your client?
I have, Judge.
In each of the cause numbers, the court will find that the state is in compliance with discovery. And you are Adrian Soto?
Yes, ma'am.
In each of the cause numbers, did you review a document entitled Application for Deferred Adjudication with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
And cause number 2023 CR 0463W. I'm showing you what's entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Did you understand by signing that you're waiving your right to have a grand jury hear the evidence in this case and make a decision on whether or not to indict? You're also waiving the right that your attorney has, namely 2 days from the presentation of the information and 10 days from the presentation of the information to prepare for trial. Did you understand? And did you intend to give up those rights?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Showing you what's entitled Information. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the information?
We do, Judge.
State, are you proceeding on the information as presented?
Yes.
And in cause number 2020 CR 2998, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Judge.
State, it appears you're proceeding on the indictment as presented. Is that correct?
Yes. Yes, sir.
I'm sorry, state.
Yes.
All right, Mr. Soto, in each of the cause numbers, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them and did you sign them in all the appropriate places? Gum goes out.
Oh, son of a.
That's okay. In each of the cause numbers, you're charged with assault, bodily injury of a security officer, and also burglary of a habitation with the intent to commit assault. The assault on the security officer is a third-degree felony. The range of punishment is anywhere from 2 to 10 years and up to a $10,000 fine. The burglary of a habitation with intent to commit assault is a second-degree felony. The range of punishment is anywhere from 2 to 20 years and the possible fine up to $10,000. Did you understand?
Yes, sir.
If you have a plea bargain agreement, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
And each of the cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes.
Did you understand by entering plea bargain agreements in these cases, you're giving up those rights?
Yes.
And did you intend to give up those rights and enter into pleas in each of these cause numbers?
Yes.
Did you understand if the court were to grant your application for deferred adjudication to the burglary of a habitation with the intent to commit assault, if for any reason your community supervision were revoked, the court could sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
And did you understand if the court were to grant your application for deferred adjudication for the assault on a security officer, if for any reason this were revoked, the court could sentence you up to 10 years in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Soto, on each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Has anyone promised you anything other than the pleas?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
And each of the cause numbers, I'm showing you the plea bargain agreement. Did you review those documents with your attorney? Did you understand them?
Yes.
And each of the cause numbers, punishment is to be assessed at 8 years in the prison. The state is opposing your applications. They were run concurrent together. And also NIGHTMAG number 679466 and 2023 CR 0463. Those are the same cause numbers and they will run concurrent. The state will take in consideration 2022 CR 3661, 2021 CR 3086, NIGHTMAG number 679462, County Court cause numbers 634960, 604888, 630-200, 634-987, 634-989. There's an affirmative finding of family violence and no contact with Augustine Elvira, Galilea Overa, and John Mello. And there's to be no contact with Bentley Beer and Garden. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the plea bargain agreement?
Yes.
State,
Yes, Your Honor.
defense?
Yes, Your Honor.
And each of the cause numbers, did you sign the paragraph entitled waiver of appeal paragraph? And did you review that with your attorney and did you understand it?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then in 2020 CR 2998, how do you plead? Guilty, not guilty, or no contest?
Okay.
And in cause number 2023 CR 0463W, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea?
Yes, yes, sir. Each case, the state offers state certificate number one. It's attached.
Any objections?
No objections, Judge.
All right, and Mr. Villarreal, I know you're working on your trial, so you can be excused.
Okay, I'll be here in the present courtroom, Judge. I'll just be sitting.
Thank you. Mr. Soto, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find in each cause number the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, and each of the cause numbers, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We will be back on March 23rd. At that time, the court will make a decision on your applications. My decision will be based upon the PSI report and any other evidence that's presented to me. Counsel, are you requesting a TAP evaluation?
I'm not judge.
Okay. Do you think he needs a TAP evaluation?
In representing him, I don't believe so, Judge. I don't think there's any substance abuse issues with him.
All right, I'm just going on the fact that in the burglary of the habitation that I read, the people in there said he appeared to be on drugs. Do you have a drug issue?
I don't, I mean, but I was on the drug.
All right, so we'll do a PSI and a TAP evaluation in each case. All right, and Ms. Ferguson will give you your reset form.
Thanks, Judge. Maybe.
Yes. All right, you can take your break. Sure. I have to view the video. Okay. All right. So what time do you want him back?
And if it needs to be extended, just let them know. If it's extended, they'll contact me tomorrow. So, yeah, yes. You're welcome.
All right. Watch this.
I can give you my laptop. Brandon.
Thank you. They gave me computers, but they have no.
Well, hopefully it works still.
Oh, if you can just give me that, just
Oh,
so
you
I
can
can
do
just
that?
put it in here. It said we didn't need this. So is this one is gonna push us past?
This one will.
Okay.
This course, it's just for initial.
All right, we're back on the record outside the presence of the jury. We have one of our interpreters back. Hello, could you raise your right hand for me? Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God? All right, you can lower your hand if you could state your name for the record. All right, thank you. All right, so with regards to State's Exhibit number 7, the court has had a chance to review State's Exhibit number 7. Defense, you had objections?
Yes, Your Honor, our objection was number one, relevance. Number two, specifically that it's prejudicial because there's already been an exhibit that I guess conveys whatever the prosecutor is trying to convey. It becomes cumulative and prejudicial after that first exhibit, Your Honor, so that's our objection.
All right, State.
Judge, as far as the relevance, the defense counsel made this relevant with regards to State's exhibit or defense exhibit number 1, when he's talking about the nature of the party and why the complainant might have, he's alleging have been excused. The videos are not cumulative in the fact that it shows other parties that are there, including other children, as well as one of the videos shows a more, the state would argue, graphic version or interaction with the kid. And so based on all those things, we don't believe it is cumulative in nature.
All right, the court has reviewed State's Exhibit number 7, and State's Exhibit number 7 is admitted, and it will be admitted in the presence of the jury.
I don't think this needs to be on the record. Do you want me to formally reoffer in front of the jury?
Yes.
Okay.
All right, let's bring the jury.
All right, for the jury.
All right, everyone, please be seated. State.
Yes, sir. Before we call the next witness, we would formally reoffer State Exhibit number 7 into evidence.
All right, defense objection to State's Exhibit number 7 is overruled. State's Exhibit number 7 is admitted. Are you requesting to publish?
Yes, Judge, I asked that. I believe you've already had it set up to be published for the jury.
All right, ladies and gentlemen, you should be able to see it on this screen. Right, and then I will play number 1. All right, for the record, State's Exhibit number 7 has been published. All right, State. Call your next witness.
Your Honor, now, the state calls Officer Rosetta.
Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you could state your name for the record.
Dean Rosetta.
All right, state.
Good afternoon, officer.
Yes, ma'am.
Will you please state your full name
Dean Joseph Rosetta.
and how are you presently employed?
I'm with officer with the San Antonio Police Department.
And where are you?
Right now, I'm stationed to North Patrol on T shift.
And when did you start with the police department?
I joined the academy in January of 2020, and then I joined patrol on the end of August in 2020.
Now, October of 2020, where were you assigned then?
That was West Patrol T shift.
And what stage of, you said you went through academy. And so you're about a month and a half in at this point.
Yes.
Are you still training at this point?
Yes, I was on FTO training, which is where you ride with an experienced officer, an FTO, to learn the ropes of how things are done before you go out on your own.
And on October 12th of 2020, do you recall responding to a sexual assault report?
Yes,
And on October 12th, how many sexual assaults have you investigated at that point?
I would have to check all reviews of all prior cases, but at this point, I believe it was my second.
And how many sexual assault, how many reports have you written about sexual assault allegation before?
At that time, it would have been my second. Now, anywhere above 50.
Now, have you reviewed your report?
Yes,
And have you reviewed your body cam?
yes.
Looking back at that time, were there things that you identified that you would do differently now that you've had more experience?
Yes.
Do you recall the name of the individual who was reporting a sexual assault on October 12th?
Yes, it was Marissa, I believe, Salazar.
Do you recall her middle name?
No, I do not.
Would it refresh your recollection to consult your report?
Yes.
Your Honor, may I approach?
Yes.
I'm gonna hand you what is, for identification purposes only, States Exhibit number 9. Is that your report?
Yes.
Okay. You can use this to refresh your recollection, but you cannot redirect.
Okay.
So please review. And tell me, can you recall her middle name?
Yes. Marissa Elizabeth Guile Salazar.
And what was her date of birth?
It would be August 22nd of 1988, 98, excuse me.
Did you identify any other individuals that day?
Yes.
Who were they?
Her boyfriend, who was Jose Perez, and then I believe he was the homeowner of the home, Kyle, and I'm not sure how to pronounce that last name, but McCalzic.
Okay. And then was there another female there?
Yes, and that was the wife of the male Kyle. Her name was Carol, same last name.
Okay. And who was your field training officer?
It was Daniel Gomez. I can't remember his badge number off the top of my head, but he still works that shift.
Okay. So do you recall when you were going out to that shift, did you have any information before you arrived?
Just what was stated on the call notes of that the caller wanted to report of sexual assault that had occurred. I believe it was 2 days before.
So when you arrived on the scene, who did you speak with first? Without going into what she said, who did you speak with first?
With the female victim.
Okay. And did you speak to anyone else?
Yes, I spoke to each of the people, residents of the house, her boyfriend, the homeowner, and his wife.
Based on what Ms. Salazar told you, did you develop a suspect for sexual assault?
Yes,
And who was that suspect?
that was the father-in-law of Kyle, the homeowner, and the father of her boyfriend, Jose.
And what was her boyfriend's middle name?
I don't believe it was told.
Who is O2 on your report?
Oh, O2 is going to be Raimundo Perez.
Okay, is that the boyfriend?
Yes,
Um. After you spoke with Ms. Salazar, did you attempt to obtain any kind of corroboration from the others
yes,
in the house?
yes. I went inside to speak with all of them.
And were you able, without going into what it is, were you able to see anything that corroborated what Ms. Salazar had reported to you?
Yes.
And what were those?
One of the individuals, Carol, had some photographs that had timestamps showing that there was a period that the male suspect had left during the party, which was the same period where she claimed the assault happened.
So did you feel that the elements for sexual assault were being articulated to you?
Yes,
Now, once you've made the determination that a sexual assault investigation has merit, what's the next step?
you would notify a detective. At this point, it was a night CID, a night investigative detective, and inform of the incident. I requested a crime scene unit to come collect physical evidence from the scene.
And what did you do after that?
I transported Ms. Salazar to Methodist Special Needs Transplant for a sexual assault nurse examination.
I forgot to ask you, did Ms. Salazar indicate whether she knew the suspect?
Yes, she did.
Did she indicate whether she before this had anything against this?
She says she had nothing against him before this.
Do you recall what you said? There were some photos with timestamps. Do you recall what the timestamps were?
Not the exact timestamps at this time, but around a period of 5:30 to 5:45, somewhere in that time gap, but I would have to review further to get those exact times.
And again, you can review your report, you just don't read directly from it.
Yes,
And do you recall how many photos you saw?
2.
Okay, and how much time was in between those?
It was 13 minutes.
And was it consistent with what you just said, around 5:30?
Yes,
So there was a time when he was there and then not there and then back.
yes.
I'll pass the witness.
Defense.
Can I approach her?
Yes.
Can I look at that exhibit? Officer, good afternoon.
Sir.
My name is Albert Flores. I'm the attorney representing Mr. Raimundo Perez in this case. I've got a few questions for you.
Yes, sir.
when you went on that report, and just because I'm gonna familiarize the jury with what your job is.
Yes, sir.
You were then and still are a patrol officer, is that correct?
Yes,
And so your job is, in the general sense, is to stop crimes that you observe, is that right?
and take report of crimes that were committed.
And I'm gonna divide it into two parts. One part is you either arrest people or you intervene when a crime has been committed, that's committed in front of you, correct?
Yes,
And then the other part of it is you're sent out to respond to certain calls, is that correct?
yes,
And in this case, that was that second part.
yes,
So you responded to a call and it was not for a crime that you've observed, right?
yes,
And so your sole job in that situation is to write information down.
yes.
Would you agree with me?
Yeah.
You don't conduct your own investigation.
We take the preliminary report to see if it meets the elements of the offense. And then at that point is, if those all elements have been met, it is referred to an investigator.
Okay, so your part is collection, categorizing of the information, right? And when you say elements, just so we can let the jury know, it's whatever elements your detective tells you, do you have information for A, B, C, D, E? Is that correct?
Yes,
So it doesn't matter if it's good information or bad information, it just has to be information.
yes,
And that's what you report, correct?
yes,
You don't question people as to whether they're telling you the truth or telling you lies. Correct?
Yeah.
You don't ask potentially for information that contradicts or may contradict what you've been told at that point, correct?
I'm not sure I understand that question. Could you repeat that?
Well, in other words, you're not trying to contradict what these people have told you. You accept for the most part what they tell you and you write it in your report.
As they tell me, yes.
I mean, unless there's something obvious.
Yeah.
You know, somebody says, well, I was driving my blue truck and the truck is red. Well, then you'd ask questions, right?
Yes,
But if you have no reason to ask questions, whatever's told to you is what ends up in this report. Is that correct?
yes, what they tell me is in the report.
So when the prosecutor asked you if the elements for the crime were met, what you really mean is that you had enough information from these people to fill in the blanks, so you could forward this to somebody else. Is that correct?
Yes,
Okay, did you do any follow-up work in this case?
no, not after the call is over.
Is it more difficult for you when you get called on a scene when the crime has taken place days before?
Sometimes it is, sometimes each call is different when it comes to it.
All right, well, let me ask you in this case, the people that were present or supposedly present on the day when this allegedly occurred were no longer there when you went, is that correct?
Each of the persons there except for your client.
So you think that all the people that were there at the party were present when you went to interview them?
Yes,
You know, it was a big party, right?
just I'm not sure I understand.
In other words, is it possible that there were people at the party?
Objection, calls for speculation.
I need to hear the question.
Is it possible that there were people at the party that you either did not interview or did not know about?
All right, that'll be sustained.
Yes,
As-
I'm sorry about that.
That's okay. Once an objection is made, I'll make a ruling.
Okay.
If you are confused as to what my ruling means, just ask me.
Okay.
All right, you can ask your next question.
Okay, you interviewed only those people that were there at the house on October 11th.
Yes,
And did you, when do you make this report? Do you type it up? Do you do it at a later date? Do you do it in the car?
in the car that same day.
So when you're actually speaking to the people, how do you document things?
In a notepad we carry on our person.
So the information goes from their mouth to your little notepad, handwritten notes,
Yes,
and then later on you transfer it and it becomes a report that looks like this.
yes,
And do you have those notes that you took on that day?
not on hand, no.
So I'm gonna direct you to your, may I approach, Your Honor?
Yes.
Your statement and in the narrative, probably the first paragraph, more or less in the middle. It appears that you interviewed Marissa Salazar, is that correct?
Yes.
Okay. And could you repeat to me, or could you read that statement that she gave to you that later ended up in your report?
It's not in evidence. Can't read from it.
What is your question?
Let me ask you this way.
Okay.
You interviewed Marissa Salazar.
Yes.
You get a statement from her with respect to what happened or may have happened.
Yes.
Correct? And based on your training, what is a sexual assault?
Would be when object, whether it's a, well, when something, whether it's an object or a body part is inserted inside one of the body cavities of a person.
So first you got to find something that is inserted, correct?
Yes,
In this case, what was inserted?
she did not know.
I'm sorry?
The Miss Salazar said she did not know what was inserted into her.
Okay. She didn't talk to you about hands?
Objection, hearsay.
That would be sustained.
She did not know.
That's correct. She did not know.
So one of the second elements that you have to fill in your blanks for is what orifice was penetrated. What orifice was penetrated based on what she told you?
Yes,
Sorry?
yes, that's correct.
Which orifice was penetrated?
She did not say.
Refresh your memory with your report, if you don't mind.
I wrote that she said it was inserted vaginally.
So she didn't say that, you just wrote it?
Yes,
She did not say that it was in her vagina,
no,
yet it ended up in your report.
yes.
And how do you explain that, officer?
At that point, she had not said it, what hole it had been inserted into. And that is what I wrote. That's what I assumed that she had referred to, because she did not correct me otherwise.
She did not correct you.
Yes, she did not say which hole it was in particular.
And you're telling the jury right now that you assumed the orifice that was penetrated was a vagina.
Yes,
But you're also telling us that she did not tell you that.
yes, that's correct.
Are you certain about that?
Yes, but she did not tell me which orifice that it had been inserted into.
And she certainly did not clarify that for you, did she?
No,
Is it possible that she used the words down there?
I don't remember what the exact phrase she used.
But she told you something was penetrated.
Yes,
You don't remember what word she used?
she said that something was inserted into her, but she did not know what.
And she did not know where.
No.
And this was within 36 hours of the event allegedly happening. Is that correct?
Yes,
In fact, you asked her whether there was ejaculate or semen present on her body.
yes, that's correct.
And that follows the assumption that you assumed that there was a penis involved. Is that correct?
Yes,
Because that's where ejaculate comes from, right?
Yeah.
Did she tell you that it was a penis?
no,
Again, you just assumed that it was.
I was asking if there had been ejaculate inside her, because she did not know what had been inside her.
So because of her confusion, that led to your confusion. Is that correct?
Objection, that's speculation, argumentative.
Sustained.
Was she clear about that issue?
No,
And her answer was, what was her answer when you asked her if there was ejaculate?
she said, I don't know.
She said, what?
She said, I didn't know, or she said, I don't know.
And then what did she say immediately after that?
She said she didn't know and that she wasn't sure what had been inside her.
Well, I mean, there's some specific words there. What words did she use?
Again, Your Honor, I would object, this is not an evidence. You can't read from it.
Your Honor, he's using the writing to refresh his memory, but I'm asking him what was said that day.
All right, that'll be sustained.
Is it true that she told you she couldn't remember what happened?
Objection, hearsay.
The objection to that will be overruled.
Is it true that she said she could not remember what happened on that day?
I'm not sure if that was the exact phrasing she used. I don't remember if that was the exact words, but she said that she was confused and shocked at what happened.
But in your report, now I can ask you, that's not what you write. You
No.
write that she could not really remember what happened.
That is what I wrote.
Isn't that correct?
Yes, that's what I wrote in my report.
Now, let's go back to your training. At this point, even though you were a new cop,
Mhm.
new police officer, right?
Yes.
You had gone to the academy,
Yes, I had.
correct? And part of the training at the academy is they teach you how to write reports. Isn't that correct?
Yes,
And part of writing a report is number one, observation, right?
yeah,
Number two, paying attention,
yes,
and then transferring that information to whatever report or whatever notes you might have. Isn't that correct?
yes.
So can we assume that what you wrote on here is correct?
I believe so, yes.
Because you were actually face to face with it, right?
Yes,
You were in a position where you could speak with her, you were asking her questions, and she was responding, correct?
yes,
So you may have regrets about what you wrote, but at the moment, that's the decision that you made to write these things. Is that correct?
oh, I'm not sure I understand that. Could you rephrase that?
Well, you may have regret about what was written, but whatever is in this report is what you transferred on that day.
Yes,
And this is the official report that was filed with your headquarters at SAPD. Correct?
Yeah.
Okay, and then later transferred and given to the prosecutors over here to my right.
yes,
Do you speak Spanish, Officer Rosetta?
no, I do not.
So I think the prosecutor started this questioning with there are things that in this report that you regret.
Yes,
And I guess you're talking about the things that I just asked you about, or those are things you regret?
Yes.
Okay. And this is two years and several months later, right, after this report was made?
yes,
Okay, and would you say your memory of the event was fresher 36 hours after it happened, or 2 years and 4 months after it happened?
it would be fresher 36 hours after it happened.
So I mean, I guess I don't know what you're trying to say. But if you wrote the word vagina, it's because somehow,
Objection to the sidebar.
Sustained.
if you wrote the word vagina, it's because there was something that you heard that led you to write the word vagina. Is that correct?
I assume that she referred to her vagina because she did not refer to any other orifice.
And if she said that she could not really remember what happened at the time, you wrote it in here because it was something that you heard.
She said she was unsure of what had happened and was shocked by what had occurred. And that is what I translated onto as on the paper.
Okay. But your words were, she could not really remember what happened. Is that correct?
Yes,
Did you spend a lot of time asking about the party from 2 days before?
Not in depth, just to set the,
And so you specifically did not ask who was present at that party, correct?
no,
So the names that you wrote down as participants in that party were only the people that were at the house when you arrived.
yes,
And you weren't handling the case by yourself, right?
no,
You had training officer.
yes,
And the training officer, did he have any part in writing the report?
no. He overview, to look through, but it was me writing it.
And he was just kind of watching you to see what you were doing,
Yes,
giving you advice maybe?
yes,
And was it you and the other officer that transported Marissa to the same nursing exam?
yes.
Now, the prosecutor asked you about a series of pictures that you had observed. And the pictures show what?
I would have to review what exactly those pictures were, but it was Carol, I believe I have her as 03, the wife of the homeowner, that she had taken some sort of picture with all of the members inside, with your client inside. At the first picture, then they took another picture 13 minutes later where he was again back in the picture. And she said during that time he was gone.
Okay. So. But you're not sure how long he was gone. You're only sure that when they decided to take pictures, it was 13 minutes apart. Is that correct?
Yes,
In other words, you don't know if the very moment Mr. Perez came back, someone snapped a picture of him.
yes. I don't know the exact time period he was gone
Okay.
except for her being within that range.
Within that range of 13 minutes, right?
Yes,
And that's all the information you have
yes.
with respect to that. So. Did you ask them who else was at the party?
No,
Objection asked and answered.
Sustained.
Who was in charge of collecting whatever evidence might still be there in the house?
it would be the crime scene unit that came out, the crime scene investigator. It was R. Rodriguez. I'm not sure of his first
So
name.
that wasn't you?
No.
Were you shown the evidence?
I was shown where the assault occurred, but I didn't look at the evidence personally myself. I did not handle any of the evidence.
Okay, you didn't, who did the photographing of the scene?
The CSI or Rodriguez.
So past the point of asking questions or writing things down, you didn't do any of the evidence collection or photographing?
No, not personally.
And how long do you think you were there at the location?
From when we got there to transporting, I think it was around maybe an hour. I'm not sure the exact, without saying the timestamps of transport.
And again, your job is just to listen, observe, and report, right?
Yes,
You don't question whether anybody was intoxicated, whether anybody was under the influence of drugs, nothing like that, right?
I asked if they were under the influence of, or if they'd been intoxicated.
Okay. And what response did you get?
That she had.
Objection hearsay.
That'll be overruled.
She said that she had been drinking as they were all at a party.
Did she tell you that she was under the influence of controlled substance?
No,
I'll pass it with you.
State.
Um, Officer Rosetta, when looking at your report, what was the report date?
That was October 12th.
Okay, well, what did you mark as the event start date?
It says May 11th.
Do you attribute that to the fact that you were still learning how to write reports?
Yes,
And when you ask, or actually, going back to what Marissa told you, did when she said she felt something inside of her, did she say where?
no,
Did you ask her where?
no,
So it's not that she didn't know where she was touched, it's that it was never asked.
yes, I did not ask her.
So when you put vagina in your report, that was your assumption.
Yes,
When you do reports now for sexual assault, do you know to ask those questions?
yes,
And when you asked her whether the defendant had ejaculated, what did she say?
she said, I don't know.
So when you put in your report that she didn't remember what happened, was that another assumption?
Yes,
And prior to testimony, you did review your body cam.
yes,
And in fact, we went and confirmed your testimony on your body cam.
yes,
From your discussions with the witnesses that were present that day, did you learn about anything to do with the fallout of when the outcry happened?
Your Honor, I'm gonna object to all of this.
All right, that'll be sustained.
Officer Rosetta, how many times have you testified?
this would be the first time.
Is it fair to say you're nervous today?
Yes,
Did Marissa tell you who was the first person was she told what had happened to her?
yes, she did.
Who was that?
That would be Kyle, the homeowner. I'm not sure how to pronounce that last name, so I don't want to.
In that time period, that 13 minutes, around 5:30, when the defendant had left, did they know where he went?
No,
Did you learn if there was any kind of confrontation afterwards?
Your Honor, I'm gonna object to all of it.
That'll be overruled.
yes,
What did you learn?
that. In this case, it'd be O2 Raimundo Perez, the son. Went and confronted his father, Jose Raimundo Perez. Confronted him, what did you do?
Your Honor, I'm gonna object to the hearsay.
Sustained.
I'll pass the witness.
Officer Rosetta, based on your based on your inquiries in your report, were there any minors there at the party?
Sorry, was there any minors?
Minors, yes.
I did not ask if there was any minors.
Were there any children at the party?
I did not ask that.
I'll pass it to John.
Nothing further.
All right, is this witness subject to recall or is this witness excused?
He's excused from the stand.
He's excused from that.
All right, the rule has been invoked. What that means is you can't discuss your testimony with anyone. The only persons you can speak to are attorneys for the state of the defense. Do you understand?
Yes.
All right, thank you. You can step down. All right, ladies and gentlemen, we're going to take our break. The good thing about us breaking at close to 5:15 is that I've saved you from rush hour traffic. So you won't have that. What I'm being informed of is that you may, depending on how the case goes, may be able to start your deliberations tomorrow. But again, I'll let you know when you can start your deliberations. You're not to do any investigation on this case. You're not to discuss this case with anyone. If you see anything or someone tries to discuss it with you, you're to ignore it. Don't pay any attention to any social media if this comes up on social media. And you're not allowed to start deliberating amongst yourselves or in your head or with anyone else. I'll let you know when it's time to deliberate. Does everyone understand? All right, pretty soon you all should be able to repeat those instructions in your mind. So we're going to start tomorrow at 9:30. I've had the cases in the court moved to a different day so that we can start with you all exactly at 9:30. And I say cases moved. There's only one case that I kept on the docket for tomorrow. So everybody should be here at 9 for that, and we'll start with this case at 9:30. Okay. All right, everyone, please rise for the jurors. Oh, you can leave the pillows if you want to leave the pillows. They will be here tomorrow for you. All right, everyone, please be seated. All right, is there, and we're not on the record, is there anything that I need to review for tomorrow, in anticipation for tomorrow?
Not from the state.
All right.
I don't know what witnesses I think he anticipated calling witnesses. Potentially there might be something depending on the witness,
All right.
but I'll try to have it as ready as possible for whatever it's a refresh of recollection or impeachment, whatever. I have those as best I can available.
All right. And defense, do you anticipate anything that I need to review before?
I don't think so.
All right. And state, how many more witnesses do you anticipate calling tomorrow?
Tomorrow.
All right. So what we'll do is we'll take the state's 2 witnesses in the morning. And then depending on where we stop, we will take our lunch break. And we'll start with your witnesses either at 1 or 1:30. It depends on when they rest with their last 2 witnesses. All right. Is there anything else from either side?
Nothing from us.
All right. I will see you all tomorrow then at 9:30.